Good morning. It's a great pleasure and honor to be part of this important and timely project. The story of tort law in the context of mitigation and adaptation is one full of tensions. On the one hand, in many systems it's extremely difficult to meet the elements for establishing liability, and hence the role of tort law appears to be limited. On the other hand, there are strong examples, such as the Dutch Shell ruling, where the court ordered Shell to reduce its Scope 1, 2 and 3 emissions, where tort law is shaped and further developed in adjudicating climate change risks. Here, tort law shows its potential for achieving legal protection against climate change risks and to hold corporations accountable. Thus, for the claimants, using tort law is a high-risk, high-reward approach. Its impact can be considerable. Think of generated media attention, the inspiration of successful cases for new cases, and other incentives for corporations that influence their climate change policies. At the same time, climate unfavorable rulings might set the standard for a considerable period and could sideline tort law. The story of tort law in climate change is also a story largely yet to be written. The main players are known, but how the plot will turn has to be seen, probably already in the near future. For example, on appeal in the Shell case, the hearings are mid-April, and in the Smith versus Fonterra case in New Zealand, but also in cases against financial institutions, such as the recently announced mitigation case of Milieudefensie, Friends of the Earth, against a Dutch bank, ING. For the future, the role of tort law will be mainly determined by how courts address fundamental challenges, such as scientific uncertainties and ambiguities, the complexity of the causes and effects of climate change, the societal consequences that tort liability could have, also for other parties than the litigants, and the effectiveness of tort law with respect to preventing climate harm and with respect to compensating it. Thus, the question to be answered is, do courts take the view that tort law can't handle these kind of challenges, as some courts did in Germany in cases against car manufacturers? Or do they adapt the law, as is also often done in the past, and find new ways in making tort law fit for a script where the issue of corporate accountability is urgent and hot? In that latter scenario, tort law could be seen as an autonomous area of law, which operation is less dependent on the behavior of other actors than the litigants, and where negative side effects of court rulings are not directly a reason for denying corporate responsibility. The toolbox and the national reports offer valuable insights in the strategies that can be followed when tackling these challenges on their legal merits. That is, however, not to say that tort law-based litigation will be a walk in the park. But I think that there are developments that justify the expectation that the link between tort law and climate change will become more clearer and compelling. To a great extent, this is because climate change adversely affects interests that are traditionally protected by tort law and even belong to the core of it, such as health, environmental, property and financial interests. Consequently, issues of climate liability are seemingly easier, note, not easy, to capture in tort law doctrines and narratives. And also, courts might see that tort law can, and maybe even should, be enriched with notions of responsibility that are enshrined in other related areas of the law, such as human rights law. In some jurisdictions, such as the EU, we see legislative developments that recognize corporate responsibility and accountability for climate change, and these developments are directly relevant for the operation of tort law. The coming years will have to show what the journey of tort law will be, and I'm grateful to be part of that journey through this great project, and I'm looking forward to working further on it.